And welcome back here to Live Now from Fox. I'm Andrew Kraft. Let's keep it moving with more of these top headlines here. Well, a very rare rebuke from Chief Justice of the Supreme Court, John Roberts, implicitly going after the Trump administration for their treatment and rhetoric surrounding the actions of a federal judge that ruled against one of their key policies of deporting some of these undocumented migrants back to their home countries. And so this is really shaping up to be quite a battle royale between two of the three branches of government here. Fox's Mike Emanuel has a closer look at this battle. Let's watch.
People in our country illegally can self-deport the easy way, or they can get deported the hard way.
In a video posted on Truth Social, President Trump urged undocumented immigrants to self-deport via the new CBP Home app.
Do it right and come back into our country. Do it wrong and you'll never be back again.
The video comes as the White House continues defending the speedy deportation of hundreds of alleged violent gang members to El Salvador after invoking the wartime law known as the Alien Enemies Act. Their removal came even as a judge gave a verbal order blocking the deportations.
The whole purpose of the act was to do this without judicial review, without courts being involved.
In court Tuesday, the Justice Department defended its actions, saying D.C. District Court Judge James Boasberg's orders were not explicit and pushed for the judge to be removed from the case. This came just hours after President Trump weighed in, writing on Truth Social, the judge should be impeached. In a rare statement, Supreme Court Chief Justice John Roberts responded to that message saying, quote, "For more than 2 centuries, it has been established that impeachment is not an appropriate response to disagreement concerning a judicial decision." White House officials say they can prove all those sent away were dangerous gang members. In Washington, Mike Emanuel, Fox News.
Mike, thanks so much. In the meantime, remember, President Trump appeared tonight on the Fox News channel's The Ingram Angle, hosted by Laura Ingram here, and was asked about this. Let's listen.
The Chief Justice said it was more than two centuries. We understood that essentially impeachment was for very rare circumstances and not an appropriate response to rulings you disagree with. What's your reaction to the courts stepping in to make a statement here? They didn't make a statement when Joe Biden, decided to forgive all those student loans. Despite
Well, he
what
didn't
the court
mention
said.
my name in the statement. I just saw it quickly. He didn't mention my name,
Yeah.
but many people have called for his impeachment, the impeachment of this judge. I don't know who the judge is, but he's radical left. He was Obama appointed. And he actually said we shouldn't be able to take criminals, killers, murderers, horrible, the worst people, gang members, gang leaders, that we shouldn't be allowed to take them out of our country. Well, that's a presidential job. That's not for a local judge to be making that determination.
Okay, there you have it. That was the response to the reaction of all of this here. We want to talk about all of this with our friend there, former federal prosecutor and legal analyst Neama Rahmani. He joins me. Neama, it's hard to know where to start here because there's so much to this. I guess first is, how rare is it for the Chief Justice of the Supreme Court to issue a statement essentially saying, we have the statement here, let's read it again. Roberts saying this: for more than 2 centuries, it has been established that impeachment is not an appropriate response to disagreement concerning a judicial decision. The normal appellate review process exists for that purpose. So, Neama, first, how rare is that, and what is Roberts trying to convey?
It is extraordinarily rare, Andrew, and this is really the second time Chief Justice Roberts has had to do this. The first time was saying that there are no Trump or Biden or appointed or judges. They are all judges, and as judges, their job is to interpret and to follow the law. So now you have these both political and other more than political attacks on federal judges. So as the Chief Justice of the Supreme Court and the head of the Article 3 branch of our government, Justice Roberts is rightfully concerned. And if the government, whether it's President Trump or the Attorney General or the Secretary of Homeland Security, they have a concern with a judge's order, that's what appellate judges are for. So Justice Roberts is right. appeal the order. Obviously, we're talking about novel issues of law. Some of these laws haven't been used for centuries. So let's have the courts interpret, let's do things the right way. So we have a plan forward in a system and we're not doing things on an ad hoc basis.
So I was going to ask you, I mean, how do you even impeach a federal judge? I want to put this up. Jake Sherman answered my question here, and you can add anything to that question. But he says, a reminder, it would take 67 senators to remove a judge from the federal bench, and that would mean 14 Democrats would have to vote with every Republican. This is very rare. It has not been done for a very long time, to the point that you were making earlier. The precedent it would set, wouldn't it just open Pandora's box, depending on who's in power, to keep impeaching federal judges over decisions the opposite party doesn't like?
That's absolutely right, Andrew. And it's really a separation of powers issue. And that's what these judges are there to do for. And let's not forget, one of the issues that the colonies had with King George in England is that he would remove judges. And they wanted, these are our founding fathers, when they put together our Constitution, they wanted judges to have lifetime appointments so they would be independent and be separated from the politics of it all. Unless it's some malfeasance, some criminal conduct, judges shouldn't be impeached just because you disagree with a decision that they're making.
So, Neama, let's get into the case at hand here. The Alien and Sedition Act of 1798. You were listening to some of those legal analysts in that report by Mike Emanuel essentially say, this was passed, this was put in place, it was enumerated with the sole intent that it's purely under the executive branch's remit. One of those legal analysts was essentially intimating the courts have no role here in interpreting this. How can that be?
Well, this is really a procedural due process issue. Here's the important thing for everyone to know. The individuals that are deported, they may well be deported. They may have absolutely no right to be here in the United States. It's just a question of can and should they see an immigration judge before they're removed from the United States. Now, under the law, there are some instances where individuals in the United States can be deported without seeing a judge. And this is one of those exceptions. Of course, under the law, the United States needs to be at war and they need to be expelling or repelling invaders to the United States. So the question is, does the law apply in this instance? And all the judge said is, let's maintain the status quo. I'm going to issue a temporary restraining order. That doesn't mean that the individuals would be released back into the United States. They'd still be in immigration custody. The question is, do they see a judge, an immigration judge? And if not, they can be deported. It's just a status quo issue. It's nothing more than that. It's not a ruling on the merits.
So, Neama, I guess the question of the hour is this. Did the Trump administration violate a federal court order? Did they go against what the judge said from the bench?
Potentially, yes. And here's the argument on the other side. Obviously, there was a verbal order and the planes were in the air, reportedly. Then the written order issues.
So what's the difference there, a verbal and a written order? If it's coming from a federal judge's mouth or hand, it's still from a federal judge, right?
It's an argument that the Department of Justice is making. I'm not saying it's going to carry the day. The other argument they're making is that the judge didn't have any jurisdiction because the individuals were no longer in the United States. Obviously, the Department of Justice and the Trump administration is appealing to try to get a new judge. They're saying that he shouldn't be ruling on this. And one really important issue is, and this may really carry the day, were these individuals deportable or removable under some other immigration law, such as Title VIII or expedited removals, such that the judge's order just limited deportations under the Alien Enemies Act. So to the extent that they may have been deportable or removable under some other law, maybe there was no violation. So potentially the judge's order wasn't as clear or as direct as it should have been. I'm not saying I agree with it, but these are the arguments that the Department of Justice will make on appeal to the DC Circuit.
Okay, I want to get to this also. This was in Axios earlier today. According to their reporting, a second administration official said Trump was not defying the judge whose ruling came too late for the planes to change course, saying, quote, "It's very important people understand we are not actively defying court orders here. But let's just stipulate for the sake of argument that a judge finds that the Trump administration did defy a court order here. How do you put the genie back into the bottle? How do you remedy that situation? These undocumented migrants, members of the very violent TDA Venezuelan gang, they're already in El Salvador. So what's the remedy if that is the case?
There may be no remedy because it's really a procedural due process issue, and it may have been ultimately harmless there. Look, our immigration system is broken, and the reason that this is such a problem is that it takes so many months, sometimes years, to get before an immigration judge, and sometimes individuals remain in the United States during that time. So what we should be doing is fixing it. But you're right. If someone has no right to be in the United States, they're what we call EWI, they entered without inspection, they have no status here, they have no right to come back, go before an immigration judge, because an immigration judge has no discretion under those circumstances. Immigration law, unlike some other areas of law like criminal and civil, it's pretty black and white. You're either entitled to be here, you're entitled to relief, you fit in a box, or you don't. So I don't expect these individuals to ever return to the United States, but it's more of a question of all the other individuals that may be the target of these types of removals. Do they have those procedural due process rights? Or do they not? It's really an important question of immigration law.
Okay.
And really, the way the law is written right now, they do appear to have these rights. So if President Trump doesn't want individuals to not have these rights, go to Congress, revise the law, bypass the immigration system, and just do things the right way, as opposed to potentially ignoring the law as it exists on the books. That's a real problem and a constitutional crisis.
Okay, Neama, one more thing while we have you, because I think this other kind of wrinkle, aside from this story, deserves some clarity, because over the weekend, President Trump issued a lengthy post on Truth Social, essentially, and I'm paraphrasing, we're going to put the post up in just a minute here, that he would rescind some of the pardons that outgoing President Biden made and ordered in the waning days of his presidency, citing this claim that President Biden didn't actually physically sign them with his own hand, that they were the result of an auto pen, an auto signature. I want to ask you this. Legally speaking, can the new president rescind pardons ordered by the previous president?
Andrew, President Trump cannot. So this is the issue. If a president, whether it's Biden or otherwise, authorizes the use of an auto pen, that's sufficient. There's nothing that requires a pardon or another executive order to have a physical signature or a wet signature. So the issue is one of authorization and intent. As long as President Joe Biden authorized the use of the auto pen and he knew he was pardoning his individuals, there's nothing that Donald Trump can do to reverse it.
Okay, and but Neama, if you're at the DOJ, if you're at the Trump DOJ and you see this, I mean, if you're sitting around in your office, I mean, what do you say to this? How do you react? I mean, do you take action? Do you ask your boss, hey, what should we do about this? Or is it just, discard it or disregard it?
Well, here's what I do, because there's a 2005 opinion by the Office of Legal Counsel, and that advises the executive branch. Those are really some of the most prestigious lawyers at the Department of Justice. And there's a memo in the DOJ files that says the use of an auto pen is okay. So the first thing I do is I say, well, we have our president who is saying something that's inconsistent with internal DOJ policies. Now, that doesn't mean those policies can be changed or rescinded. But right now, as far as the guidance that's on the books, that says this is okay.
Right. Neama Rahmani, we're going to have to leave it at that. Neama, always a pleasure. We'll talk soon.